What is the test for leave to appeal to the Court of Appeal? First question, which court must determine what the test is? It should be the Court of Appeal, according to the federal court decision in a case called Lam Kong Company Limited. Second, has the Court of Appeal decided what the test should be for leave under Section 68 sub 1 sub A of the Courts of Judicature Act? The answer is no, not really. Next, we should speak about two opposing cases which are relevant. The first is the old High Court case of Pan Hong Chin versus Nahar Singh that was decided in 1986. The second is the latest 2020 Court of Appeal case of Country Garden Danga Bay Sundayan Berhad. Now, the Nahar Singh test is based on two English cases. They are called Gilchrist and Buckle respectively. Let's deal with Nahar Singh first. There, the defendant applied for leave to appeal, but he had to withdraw it because he was out of time. Having dismissed the application, Mr. Justice Edgar Joseph Jr. then took it upon himself to make, as he says, one or two general observations about the law on Section 68 sub 1A and leave applications. So much of what he said afterwards was strictly obiter dicta. It is in the course of this obiter discussion that the judge prescribed what has now come to be known as a three-limb test for leave to appeal. The first is the applicant must demonstrate a prima facie case of error. He then adds two further but alternative limbs. The application, he says, in the second alternative limb must require a question of general principle decided for the first time, or the third limb, a question of importance upon which further argument and decision of the federal court would be to the public advantage. Now, in support of this prima facie two-limb test, the judge cites two English Court of Appeal decisions. The first is ex parte Gilchrist, and the second is a case called Buckle and Holmes, decided in 1926. Now, the question in Gilchrist was whether a right to appoint a trustee amounted to property. The test for a leave application was not a central or even an incidental question in Gilchrist. The Gilchrist case was peculiar. In English common law, as you would already know, a married woman could not be declared a bankrupt. However, if she traded separately from her husband, she could be. Now, in Gilchrist, a married woman had a business separate from that of her husband. She was declared a bankrupt. Meanwhile, a third party had bequeathed her some property, a life interest. That property was to pass to her descendants. Under that bequest, she had a right to appoint someone as a trustee under a deed, but she hadn't done so. Now, the question in that case was her right to appoint a trustee property? If it was property, then her rights passed into the hands of the official assignee. If the answer was no, she could transfer her entire rights by deed without being disturbed by the official assignee. The Court of Appeal, distinguishing a power of appointment over property as opposed to the property itself, ruled that the right of appointment was not property. Because it was not property, that right could not pass into the bankrupt's estate. Now, much earlier, the divisional court had ruled against her. She asked for leave to appeal. The divisional court refused to grant her leave to appeal. It is at this point that things get interesting. Do you want to know why the divisional court refused her leave? It was because they thought they were not wrong. In the Court of Appeal, the Master of the Rolls, Lord Esher, chides them. The divisional court's jurisdiction to grant or refuse leave was not dependent on such a view because, remarked the Master of the Rolls, Lord Esher, the question was one of law that had arisen for the first time. What Lord Esher in fact said was, and it is obiter dicta, is this: merely to say that they are satisfied their decision is right is not a sufficient reason for refusing leave to appeal. When the question involved is one of principle and they have decided it for the first time, if that was carried to its legitimate conclusion, they ought to refuse leave to appeal in every case. You note immediately that the master of the rolls did not determine that every leave application for leave required the applicant to show that there was a question of law that had arisen for the first time. So, Mr. Justice Edgar Joseph Jr, with respect, misunderstood and mischaracterized the point behind Gilchrist. Now, I want to speak about a case that involved the laws of cats, dogs, and birds. We deal with the next case Mr. Justice Edgar relied on. It was the entertaining case of Buckle versus Holmes. It occurred in 1925. Buckle was a pigeon lover. Holmes, his neighbor, reared a cat. The cat killed Buckle's 13 pigeons and 2 bantams. Bantams are chicken. Buckle sued Holmes. The question was Holmes, as the owner of the cat, liable for the acts of his cat? The Court of Appeal held that as an owner of an animal, for example, that of a cat or a dog, he wasn't liable. The owner wasn't bound to keep an animal from straying. If it did damage, he wasn't liable. What had that to do with Section 68, subsection 1? Nothing really. However, in that case, Lord Justice Banks thought that the court should grant leave to appeal on this point about cats and dogs. Not because, said he, we thought there was any real doubt about the law, but because the question was one of general importance and one upon which further argument and decision of this court would be to public advantage. Does it sound familiar? Again, there was nothing there about a leave test. Now, there are serious doubts in the way the case of Nahar Singh formulates the leave test in 1986. And I'll give you 5 reasons why I think Nahar Singh is unreliable. First, Mr. Justice Edgar's tests are identical to the Section 96A test of the Courts of Judicature Act, which is a test for leave to appeal to the federal court. Again, that section expressly sets out the 2 limbs, but Section 68 sub 1 doesn't. Second, the Section 96A test is of a very high threshold. If so, how can it be prima facie? Third, the words in Section 68(1)(a) say nothing about an applicant requiring to prove a prima facie case of error or a question of law that had arisen for the first time, or indeed a question of general importance upon which further argument and a decision of the court would be to the public advantage. The fourth reason is, why is it that a poorer person with a lesser judgment has to overcome a steeper test while those with a larger amount sail right through? That's not fair. I think in Danga Bay the judges were conscious of that. And the fifth point is, to agree with the Nahar Singh test would be to read into Section 68 sub 1A 3 high hurdles even Parliament didn't think to impose on Section 68. So, in 2020, the Court of Appeal formulated another test in a case called County Garden Danga Basin Rian. Now, this is what the court said in that case. The requirement for leave serves as a filter against frivolous or unmeritorious proceedings. So, the Danga Bay test substantially lowers the threshold for a leave application compared to the Nahar Singh case. The court seemed to formulate a negative test. The court seems to suggest that it would grant leave if the case was non-frivolous or not unmeritorious. But the Danga Bay test itself is not free from doubt or error. First, these 2 words, non-frivolous or not unmeritorious, do not appear in the Section 68 sub 1A test. One can hear the protest of our judges. If no test has been formulated, should we not structure our own? The answer is of course. But how high or how low should a test be pitched? Do the words frivolous and unmeritorious mean the same thing? The judges in the Danga Bay case treated each of the 2 words, non-frivolous and unmeritorious, as if they meant the same thing. I think these 2 words have 2 different legal heights. So what does non-frivolous mean? For a start, frivolous means trivial or time-wasting. It could also mean petty or, if you want to stretch it, worthless. A more familiar and better set of words are obviously unsustainable. And these words, as regards the word frivolous, were spoken by Lord Justice Lindley 128 years ago in a case called the Attorney General of the Duchy of Lancaster and London and North Western Railway in 1892. Now, if you want a transpontine authority, an authority across a river, which is where Putrajaya is, look no further than the 2020 Federal Court case of Tony Poir, which defined the word frivolous as giving rise to no other inference than that it is wholly indefensible or unsustainable. So that is a really low test. Now contrast that with the meaning of the word unmeritorious. A meritorious case means a case that will succeed. An unmeritorious one means a case that will fail. The 2017 Chancery Division case of Housemaker Services Limited and Co. defined an unmeritorious case as one having no real prospect of success. To determine that an appeal is unmeritorious naturally requires a full consideration of the merits of the case, which is what? As good as arguing the substantive appeal itself. So the word unmeritorious results in a far higher test, far higher than the word non-frivolous. If you contrast an unmeritorious appeal with a non-frivolous appeal, a non-frivolous appeal has a lower test than that of an unmeritorious one. The next point is the proper test, therefore, is still very much open. I hope at some point the Court of Appeal will resolve this uncertainty. So what should the test be? In my experience, the Court of Appeal has denied leave only in the most unusual of circumstances, probably where the leave was wholly unsustainable. This reminds one of the striking out test in Order 18 Rule 19 proceedings. If one weighs the dicta of Mr. Justice Harminder, who spoke for the entire bench in the Court of Appeal in the Country Garden Danga Bay case, the court's keen eyes seem to look directly to the test in Order 18 Rule 19. And I think that should be the test. The words unmeritorious or non-frivolous should, with respect, be jettisoned. And they should be jettisoned in favor of the well-worn phrase, obviously unsustainable. That would be far better and result in a fairer test. Thank you very much. Please share this video widely, subscribe, like, comment, and ring that bell so that I can bring you more and more interesting subjects. Goodbye.